Good evening. This is Laws 11057, Introduction to Law. It's week 5. We're dealing with chapters 9 and 10 of The New Lawyer. We're also going to deal with some homework issues. The homework that we had related to legal research. And one of our students, who is also a lawyer, admitted in the UK, Catherine Wood, has kindly volunteered to lead us through that discussion. What Catherine will do is show you the way she went about doing the legal research. There are different ways to achieve the same result. So I'll be interested to hear from others as to how they went about undertaking the legal research. Catherine, if I may hand it over to you now, I'll go on mute. Thank you.
Thank you. Hi everyone. John, as he says, has quite kindly asked me to go through my homework and the legal research that I did. I think there are various different ways, different means, different places to look for acts and for statutes. I'll just go through how I did it and how I've done it for quite a few years. I'm going to try and share my screen and hopefully that will work. Hopefully we can see Google. Thank you. Okay, I personally prefer OSLE, and I believe John in the homework assignment also referred to OSLE as one of his ways that he uses to do legal research. I'm pretty basic with a lot of my searches, at least as a start. Obviously, if you can't find things, I'd go a little bit further advanced. As a basic, I always tend to use the advanced search. I just find that it brings up better results. You can obviously choose a legislation, you can choose whether you're searching case law, but it also responds pretty well to general searches as well. The first item of homework was John asked us to find section 754 of the Police Powers and Responsibilities Act. I went for a nice, easy search term. I chose Police Powers and Responsibilities Act, and I also added on to there as an extra search term the section, so Police Powers Responsibilities Act and 754. Do a search for those terms, and a lot of times that comes up. Sometimes it brings up some bizarre results. In this instance, it's there at the top, nice and easy. Straight into the legislation from there. You can see you're in the right section. It's got 754 at the top, a bit of a clue. That's how that works. You can see exactly what the section's about. In terms of then looking for case law from there, as was also requested. OSLE's got a great function in that you can go straight to Note Up, which brings up any cases that are mentioning that particular section. I chose, you can see highlighted, Police versus Stewart, mainly because it was at the top of the list. I did have a quick look at the other ones. This one was a little bit easier to understand. As you scroll through, the other thing that OSLE also does is it puts green arrows, as you've probably noticed, next to the relevant sections that you're looking for, which if you click on it will take you down to the relevant, where the relevant section's quoted. So that makes it nice and easy to find what you're looking for if you're just wanting a particular provision. Obviously, if you're wanting to look a little bit further into the case, then you'll need to have a good read through that. That was the first question that was set for us. The second one I found a little bit more difficult. I did try again as a favourite, straight through to OSLE Advanced Search. This task was to look for section 24 of the Criminal Code Queensland. I did try typing in various search terms, Criminal Code Act, Criminal Code Queensland. Came up with some, on just a general search, some pretty interesting and not really relevant results. I'm not actually that confident in OSLE at times for looking perhaps for up-to-date legislation or knowing whether it's up to date. Rather than going through all the separate different search terms, I went for an easier option, in my opinion. John may differ on that one. As I knew it was Queensland legislation, that made it quite easy. I chose Queensland legislation government site. Again, different people do things different ways. There are easier ways through Ofsted just to choose Queensland legislation and to search through there. I personally preferred to come this way. Again, it's quite straightforward. Sorry, I should start at the beginning. So into current legislation. Also by alphabetical is probably the easiest way to search. So C for the criminal code. And you also know with the Queensland legislation, obviously it's current in this database, so you're not going to be looking at something that's been repealed or something that no longer is in force. You'll find the Criminal Code Act there, easy to click on, opens up the Act, you can see what you're looking for. I could see that it was current as at the 5th of September, so I knew I was looking in the right place and that I'd got the right year. And then I cheated for this one. Google is always a wonderful tool. So Google for this one, I chose just to literally type in the section 24 Criminal Code Queensland, and I just put Ofsted at the end of it to find the link direct into Ofsted, knowing that I needed at some point to then look for a case to that actually relates to that particular section. So press obviously the link, takes you straight into the relevant section on Ofsted of where you need to be. Doesn't always work, but it seems to work a lot of the time. And again, to find the case law, click on Note Up, and it brings up 2 cases that quote that particular section, that cite that particular section. I hope that's pretty straightforward in that respect. Moving on then, the third question that John set was to find Schedule 2 of the Competition and Consumer Act 2010. This is a Commonwealth Act. So to find the Commonwealth legislation, I tend to use the ComLaw homepage, the ComLaw website. From there into Acts, and again that's got a list of all the current acts. Competition and Consumer Act, there's an alphabetical section down in the current, obviously begins with CO, which hopefully at some point will actually work. A little bit slow this evening. Just having a think. And again, we've got an alphabetical list there of all the acts and statutes beginning with CO. So the Competition and Consumer Act. It's on page 2. Maybe the ComLaw website's quite busy this evening. So the Competition and Consumer Act 2010. You can see that it's current and it's the authoritative version. Once you click on the Act in here, it's quite a good website in that it does bring up on the left-hand side all the different sections, all the different sections, all the different provisions, the different parts. This one's quite a big one, so it has got a few volumes. We're looking for Schedule 2, which I do know from looking previously is in Volume 3. And then you can find Schedule 2 is there at the bottom, which is again the one that John was looking for. So you can see that that relates to the Australian consumer law, which again, in line with the question, is what John was looking for. And that was quite easy to find that one, I think. The final question, John was looking for the Fair Trading Act, section 16. And again, for that one, given that it's Queensland legislation, again, I just use the Queensland legislation site into current legislation. F for the Fair Trading Act, and there it is, nice and easy at the top. Any questions? All straightforward, I hope. And I think
Thanks.
people probably do that quite differently. And as John, I'm sure you're going to go through now and say other ways and how you perhaps do that.
Well, no, thank you very much, Catherine. I'm really interested to see if other people would like to offer any alternative ways of dealing with that research question. And thank you very much, Catherine. That was terrific.
Thank you.
Does there anyone else wish to make a comment or provide a suggestion? You can hit, now how did you do that, Catherine? You put share screen. Thanks, Catherine. All right, so who have we got here? Is that Julie?
Me. Jackie.
Okay. Oh, Jackie, sorry. Would you like us to, do you wish to show, want us to show a different way, or do you want to demonstrate a different way of doing the research, Jackie?
Sorry, I've come in. I've just come in. I've missed
All right.
it, John.
No, that's all right. Well, I'll just mute you. Now, is there
You're
anyone,
what?
I'll just put you on mute, so we can't hear you now. Thank you. Does anyone else have any comments about that? Anyone wish to offer a different way? Okay. Now, just so I know where we're at, can are people looking at my screen? Okay.
Yeah.
All right. I'll just share my screen, just show you a slightly different way that I do things. Sorry, I'm getting there. Very slowly. What do you see at the moment?
Google website.
Okay. You can see Ostly? Or you can see my cursor moving around?
Yeah.
All right.
Yeah.
So the way I do it's slightly different. I go into Ostly. Over on the left-hand side, we have cases and legislation. Select Queensland. I then go through one of the databases, in this case, legislation, to look at consolidated acts. From there, I select P for police powers. You'll see these are alphabetical. Police Powers and Responsibilities Act, and very old-fashioned cursor down to 754. So probably a more complicated way than Catherine's, but one that I guess become familiar with. 754, note up, as Catherine mentioned, we have Stewart's case and Forbes and Jingle. Same for the Commonwealth legislation. Go back. Shouldn't hit the back key. I'm sure someone will say there's a much more efficient way of doing that. If we're looking for Commonwealth legislation, I'd go in through that database down to Acts, Competition and Consumer. Act. And down to the bottom where we have the Australian Consumer Law. If you can see my screen, so there's the that's the Australian Consumer Law. Okay. Any questions about that? Does anyone wish to offer any other alternatives? Here's your chance. All right. Well, thank you very much for that, Catherine. Really appreciate it. Did someone wish to make a comment? All right. I'll just mention that case of Forbes and Jingle. That was a really interesting one. It came out in September of this year. Judge Harrison of the District Court upheld a decision of a magistrate which enabled the court to make a probation order in relation to the matter of Section 754, which deals with failing to stop. So the government, as part of its Get Tough on Hoons legislation, introduced legislation that effectively said if someone fails to stop when required to do so by police and continue to drive on, then they will be guilty, and there are certain minimum penalties, and there are only two. The minimum penalties specified in the Act are 100 days of imprisonment, wholly served, 100 penalty units, which is $5,500, or 50 days imprisonment, wholly served in a correctional services facility. In other words, before this decision of Forbes and Jingle came out, magistrates felt that they had no alternative but to impose a fine of either $5,500 or send someone to prison for 50 days of actual time for failing to stop. This case is interesting because the magistrate said, I'm going to impose probation, and ultimately the court said that probation was still available in these circumstances because probation is available as a sentencing option in any circumstances where jail is possible, and the court held that even though it wasn't specified as a sentencing option in the legislation, it was still available to a sentencing court. I mention that because, like many things, you're always thinking about the separation of powers and this kind of inherent conflict between legislation which is introduced and the court's desire on some occasions to resist implementing that in a way in which I think Parliament would expect it to be implemented. So that was that was Forbes and Jingle. Now, are there any questions? If not, we'll move on to what was discussed in the set for the course for tonight. Any questions?
John, with
Yes.
the penalty units, how do you actually find out the monetary value that's assigned to a penalty unit?
Thanks, Peter. It's set by regulation. When they first introduced the concept of penalty units, it was $100, as I recall, per unit. That's been increased to $110 per unit. Now, why on earth do you think they would bring in this concept of penalty units? Does anyone have an idea?
I don't know, but I was just about to ask you that.
Okay. Well,
I think isn't it that it remains constant throughout, no matter what act. A penalty unit has the same monetary value right throughout.
Yes, that's a really good reason. So there's some sort of consistency. People can compare apples with apples in a sense. So thanks, Erin. Any other reasons that people might suggest?
I guess it's so they can also increase the dollar amount without actually having to change the legislation.
Exactly. Thank you, Catherine. Because there are so many pieces of legislation that impose penalties, it's much easier to change one piece of legislation and say a penalty unit, wherever it is now worth $120 rather than laboriously going through 5,000 acts and changing them. So that's the common sense rationale behind it. So thank you, Erin. Thank you, Catherine, for that. Okay, well, look, let's move on. Your reading for this week is chapters 9 and 10, Communication and Collaboration Skills. I will just ask this. Has everyone, before I start, I meant to ask, has everyone had a look at Jade Barnett? I'm really keen on Osley, but I really like Jade Barnett as well. And you can subscribe.
I like it too.
Good. Have you subscribed, Erin?
Yes, I have. I've only subscribed in about 4 different areas.
Yes.
That was before I started studying, but yeah, a lot of really interesting. There's a couple of interesting cases they posted today, so it's well worth it because you get the most up-to-date cases in various areas.
It's absolutely terrific. So I'm pleased that you've subscribed, Erin, and just imagine how good you will look in an examination if you can cite a decision of a court that came out last week or yesterday. How much kudos will you have for that? So I guess there's a big hint there. Go on the site for Jade Barnett, register, it's free, and in your inbox every morning you will get a list of the cases that were decided or published the day before that are relevant to your areas of interest. I would suggest that you don't tick every box, be selective, otherwise you will be swamped with thousands of decisions. So that's Jade Barnett. Now, I'm going to ask a favour, and that is, having subscribed, I want to change my areas of interest, but I haven't worked out how to do that. So if anyone does subscribe and then manages to successfully change the areas of interest for the cases, could you please let me know? I could pretend it's a test, but I actually don't know, so I'd really appreciate it.
I think they actually give you a link, John.
Yes, I couldn't work it out. You'll have to send me an email, Erin, because I'm a bit technically, or maybe you could show us through a screenshot or something if you succeed. I did get that link, but I couldn't make it work. So thank you.
Okay.
All right. Have a look at page 307 of the New Lawyer. Have a look at the short sentences at the start. That's really what I'm after. Lawyers are essentially wordsmiths. They are experts at working with words in both written and spoken form. For this reason, learning how to communicate effectively in writing and orally is a critical focus for law students. I really like that. That's a great paragraph. There is an effective list on page 306 for you to look at in terms of communication and collaboration skills. On page 307, there's something that I don't really like, and you'll see this in my marking a bit. I'm not terribly keen on lists. Now, just have a look at page 307, and I don't mean to be critical of the authors because I think they're great. But the heading is, the emphasis in TLO5 upon effective, appropriate and persuasive communication with various audiences is consistent with, and then there's a whole lot of things. Now, can I just be honest with me? Do you actually read that, or do you gloss over it? Do you switch off and just gloss over it? Because I do the latter. I just kind of switch off, gloss over it. So if you present lists like that in your paperwork with me, you'll probably get marked down. And it's your opportunity to say that I'm wrong and I'm being unfair in that regard, because it's the most efficient way to do things. All right. Well, everyone agrees with me. Tara, do you wish to make any comment?
Yeah. So with lists, would you prefer that there was, because I'd prefer there to be spaces in between the points.
Yes.
But
I
that
do
makes
like,
it easier to read.
Yeah, I think having spaces in between does make it easier. Maybe just the visual part of that, and even on page 306, it just doesn't suit my eye.
No, I don't like it either.
But the point is, yeah, thanks, Tara. So the point is that you need to be a little creative, and you need to think about the reader in terms of what's the easiest way to take things in. All right. Have a look at the think box on page 307. Lawyers talk try to think in terms of clear and precise communication, use short words and easy to understand phrases. So do you think of lawyers using legalese, jargonistic language with long words used in incomprehensible sentences? Or do you think about lawyers communicating with short sentences and easy to understand phrases? I imagine before you came into this course that you think about lawyers as being quite pompous, using technical language, throwing in Latin wherever possible, and not using simple language. Well, if that was the case, and I suspect many people do, we want to change that. short sentences, simple concepts. Look, by all means, throw in the odd word, which is going to impress, but for the most part, keep it simple. All right, let's talk about interviewing clients. We're talking about communication skills verbally. I'm just going to ask people to fire away. Either you can say this or you can type it in. But tell me, what do you think are the most important attributes a lawyer can have when interviewing clients? All right, fire away. Let's see what we come up with. And I'll read the answers as they come through on the chat line.
I'd say listening and communicating though, John.
Yes, Josh, absolutely. Listening. How carefully do you listen, Josh?
Everything.
Very carefully. Good. What else have we got? There's nothing come through on the chat line. There's a few now. Body language, and that'll say you're interested. Empathy. Empathy again. Be easy to understand and great listening skills. Empathy. All right, we're getting some good answers coming through here. I'm not sure if I missed any. Short with big words. No. Okay. So a lot of empathy. I like that.
When you
adding that
talk
to
to them,
my
John,
list. Yes.
yeah, when you talk to them, John, you talk in a language they can understand.
Exactly. There's really no point, is there, in being pompous and saying things that people don't understand. As a mediator, I need to be very careful about that, because things that you think people would understand, they don't really understand. I used to introduce in my mediations the concept of me being a facilitator. And on one occasion, someone said, I don't understand what you mean by a facilitator. So, you've just got to try and scale it back. And there's nothing wrong with that. In fact, that's to be applauded. Make sure they understand, says Vicky. I agree with that. All right. Maintain. Yes.
I was just going to say, John, just keep checking with them. Is there anything they want to ask about along the way rather than waiting till you get to the end?
Absolutely. Leaving gaps is appropriate. What happens if it works the other way and the client just won't stop talking? What do you do then? It's all part of interview technique. What do you do?
I guess you've got to be able to direct them back onto what is relevant.
Mm-hmm. Yes, I agree with that.
Yeah.
If they're talking too much, I guess you just pull them up and then start over where you want to start.
You can do. You've got to be careful it doesn't become a screaming match between you and your client if they won't shut up and you want to get your point across. So what happens if it's really dramatic and they just really they won't stop talking?
Offer them a cup of tea or a scotch if you've got it.
Yep. I can tell you from time to time, I'll just stop showing interest. I'll just turn my head until they get the idea. And then when you do bring them back in, you just remind them, hey, you're here for advice, happy to give you the advice, but you need to leave some gaps. So you can be quite firm but nice and still empathetic with the clients. In a way, it's for their own good. So silence is sometimes a very effective technique. All right. Maintaining eye contact. It's all part of body language. It's showing that you're interested. Sitting up, being attentive. Try not to be distracted by things. How on earth do you deal with the issue of taking notes of the conversation, but also engaging in the conversation? So let's take this scenario. You have a difficult client, very stressed, not taking a lot in. You're trying to explain some important and urgent concepts. Things blow up in your face. In 6 months' time, you've got the Legal Services Commission on the phone. Hey, this client says you didn't advise them properly. You know exactly what you said, and you said all the right things, but the client's saying you didn't tell me that. How do we deal with that situation of showing empathy, showing interest, maintaining eye contact, but taking notes at the same time, or guarding yourself against a claim. All right, so gain their trust first, and then take file notes, and file notes. Tape record the meeting. Reflect back to them the major points and make notations. Great answers.
You just be open right from the start and tell them that you're listening to what they're saying, but you need to take notes. And I'll ask questions when we need to, and pull me up if you don't understand anything. Just being really upfront at the start.
Excellent. Oh, that's great. And showing that interest and that enthusiasm and making it all part of them. So that's a great answer, Vicky. Thank you very much. Online, we're getting explain to the client that you are taking notes. After the meeting, confirm your meeting in a letter to them. That's a great idea, Jackie, or Julie, sorry. And send a letter after the covering what you talked about. Thanks, Laurie. So they're all really good techniques. Tell you one I use. I do take notes somewhat selectively, but very often I'll use voice recognition software. So I don't know if any of you are using voice recognition software. I've probably spoken about it in this course already. I use the Dragon Professional, and to me, it's very effective. So sometimes if I'm taking a statement from a client, I will do that directly while they're sitting there, and I make it part of the conversation. What they don't see is that I push the play button, which means that what I'm saying is actually being typed, as it were, on the screen. So from the client's perspective, it looks like I'm feeding back the information by way of confirming the details, but what I'm actually doing is having it typed, and I can see it being typed on the screen as I go. So it's kind of a good way of doing both. Josh says, I try to find some common ground, so if the conversation does start to get heated, it gives you a safe zone to go back to. That's a good idea as well. All right, make sure that you receive appropriate responses to some various questions. A couple of key questions. What do you want? And what do you want me to do? So have a couple of basic questions ready to go, and make sure that you're satisfied that by the time the interview is finished, you have an appropriate response to those questions. Clear instructions. Absolutely, Tara. Thank you. Make the client feel comfortable. Treat the client with respect. Very importantly, don't jump in too quickly. Let them have their say. Maybe they'll come up with some information that you hadn't thought of, or that surprises you. Sometimes they need to vent a bit too. And I hope you're taking notes, because this is all examinable stuff. Inform them to bring a support person if they want to. That's a good idea as well. Ensure the client is aware of your obligations with respect to confidentiality. I think that's a really good way of ensuring that there's trust and the client knows that they can speak freely. Confirm the instructions in writing or obtain evidence of the interview. Someone mentioned tape recording. Just need to be careful with tape recording, but generally there's no problem at law with that. Okay, any questions then about interview techniques? We've talked about writing techniques. We've talked about interview techniques. Can I just add another one when it comes to examination techniques or assignment techniques? I really like innovative ways of doing things. I mean, for example, on page 309, there's a lovely little chart, and that's a very effective way of communicating. I take environmental law, and a lot of people will explain, you know, the process of fracking, etc., by reference to charts and diagrams, and I think that's a really effective way to do it. So keep that in mind as well. All right, so in other words, be inventive. Taking action, negotiation, page 311. This is all about how to negotiate, the adversarial approach to negotiation, the different ways that negotiation can take place. Interest-based approach to negotiation is something that's favoured. I do take alternative dispute resolution. I hope I get it again. And in that, we do a lot of work in terms of the difference between the adversarial approach to negotiation and interest-based approach to negotiation. In short, I can say that interest-based negotiation is where one is not attempting to score points or rely on principles or my position is, but really try to think about the interests, the real interests of the parties. And when you're negotiating, or even with a client, you should really try to be thinking about what's in their, what is their interest in this, rather than what is their position in this. Now, is anyone confused by the difference between interest and position? Well, let me give you an example. If you have a dispute between a couple, the position might be that of the lady concerned that he is spending too much money and too much beer at the pub. Her interest is to ensure that they can work well enough in a family unit to ensure that they're economically viable and safe, and the kids are looked after. So it may be that her position is quite different to her overall interest. And if you can negotiate around interest and try to put the positions of the parties aside for a bit, you may achieve a better result in negotiation. Probably don't have much more time than that to go into it.
So, John, just quickly, the position's affecting both parties, whereas the interest is only affecting one of the parties. Is that right?
Not necessarily. The interest will be affecting both parties. I mean, let's say you're dealing with commercial clients in a partnership dispute. It may be that we stop talking about the length of time that one of the partners has for lunch, or the fact that they don't bring as much business in as the other one. I mean, that's important, and that needs to be considered. But let's get that out into the open, and now let's start talking about what is in the real interest of the parties. And it might be that the party that's complaining about the other one not bringing in enough business, their real interest in this is to ensure that they have enough money coming in to continue paying their car loan, because they really want their car. That's really important to them. So that's their interest. And the more that we can sort of focus on those things, generally speaking, the better. Okay, thank you.
Thanks for that.
All right, thanks, Josh. On page 310, we have the issues regarding the constructive approach to negotiation. Now, this reminds me very much of mediation. So if you have a look there, there's 10 on the list. Prepare for the negotiation, open the negotiations with a problem-solving focus, build trust and relationship, gather information, set the agenda, explore each party's interests, we talked about that, generate options, solve problems and bargain, state the outcome, document it, and do some reflective debriefing. That's almost exactly the opening that we would use as a mediator in a mediation process. And it follows that pattern of trying to gather information, set the agenda, and then going about exploring options once we've determined what parties' interests really are. I'm highlighting that because even though it looks very basic, if you work your way through that, you'll see it has a lot of application for your legal careers generally. So that's on page 312. On page 313, I've got a lot of highlighting and a lot of notes because I like this bit, and it's talking about advocacy. So far we've been talking about communication in terms of writing and interviewing and oral presentations. Advocacy is a little different. So effective advocacy, there's a list there of things that you need to consider. You need to have your research skills, reasoning, ability to find information, argue persuasively, manage ethical dilemmas, and reflective practice skills. And the practical aspects of courtroom advocacy are set out there as well. Have a good look at that. Because, and again, this is examinable. We will talk more about this, but I want you to be in a position where you understand what you need to do to become a good advocate in a courtroom setting. So I'll just give two brief examples. The first is you have been called in to do a bail application for someone who's in the watch house about to go over to the courtroom, and police are objecting to this person being released. You know, how do you go about the process of preparing your mind ready to address the court? Part of it is you need to know the law, but you also need to know the client's instructions, and you must have a clear idea of what you're trying to achieve at the end of the day. What you wish to do is persuade the court that it is appropriate for the court to grant an order that this particular person should be given bail. You, being an advocate, requires you to consider some of the what-ifs. The court's concerns should be addressed. So, in making the bail application in those circumstances, what you might think about and speak to the client about are some of the things that might trouble the magistrate. The magistrate might be worried that the defendant will abscond and not turn up at court. So you speak to the client about that. The client, the magistrate might be more willing to give bail if you can show the court that this person has somewhere to live, or that this person has work to go to, or has commitments with family, etc. So think about what you wish to achieve, think about the impediments in getting there, and essentially work backwards. So have a good look at that list of that practical aspects of advocacy, which is on page 313. To give a different example of advocacy that you might get involved in, you have a client comes to you and says, look, I've been away for 2 months, I've come back and I see that someone has taken a judgment against me. If I was here, I would have defended it, put in a defence. So now I need to get rid of this judgment so I can relitigate. What that means is you need to make an application to set aside the judgment, and you have to consider what is the court going to think about before making the decision to set aside the judgment. Well, there's probably two things. The first is the court will want to know that it's not just setting it aside for the sake of it, but you've actually got a real and arguable defence. So you might need some proof about that. And the second is the court will be interested for the reason for the delay. So again, you're thinking about what the court might want, and you're then tailoring your submissions and your approach accordingly. Sometimes, particularly as a new lawyer, having written submissions is a very good way to go. It's good for two reasons. The first is it provides you with a focus, so you have to order your thoughts and reflect that in your written submission. And the second is it makes it easier when you're on your feet. You've got something to hand up. It also makes it easier for the court to follow what you've written and hopefully make the decision accordingly. Sometimes it's good to make concessions. Don't be doggedly determined on every point. Sometimes it's good to give away a little bit because you might gain more in different ways. And always consider the alternative argument. So if you were acting for the other side, what would you do? And that's great for your preparation in terms of what you might come up with in court. Understanding the audience, looking for clues from the magistrate or the judge is important as well. If it's clear from body language that he or she has made up his mind, then you don't want to annoy his or her honour more than you have to. Okay, I've been moving pretty quickly, and that is your introduction to courtroom advocacy technique. That was pretty quick, wasn't it? Any questions? You're all prepared? So first year lawyers, you're all ready to do your first bail application now? That's good. Okay. Yeah, I'm getting a lot of, everybody's ready to go. We're right. Assignments and exams. Have a good look at page 319. Assignments, they need to be well written, focused, analytical rather than descriptive, well structured, logically argued. I am really determined to ensure that everyone who leaves this course presents their papers professionally. And you will get marked down from now on. If I don't like the presentation, you will get marked down. Now, having said that, that doesn't mean you have to follow exactly the format that I use. If you think that Times New Roman is a better font than Calibri, fine, use Times New Roman. If you think 10 point is better than 12 point, use 10 point. But do be consistent. Now, who was it that made the excellent comment before about leaving gaps? Was that you, Tara?
Yeah, that was me.
Yeah, thanks, Tara. Leave some spaces. And if you're going to leave spaces between paragraphs, make them consistent. If you're going to have headings, which is great, make sure that they're all the same style, they're all the same font, all the same point, and there's the same gaps between the commentary, the text, and the headings, etc. Make sure that you use footnote referencing. We don't use Harvard in law school. So you need to have a good grasping of footnotes. But it's so simple, isn't it, using the word version? Nobody here would have any problem with using footnotes. We all know how to do it. Okay. A great guide is keep your eyes and wits about you when you're reading material. When you're reading a case, don't just read the words, but have a look at the way in which the court structures the material. Have a look at the way in which things are referenced. Have a look at the way the footnote is structured. Think about things like indenting a quotation. Observe that in proceedings, often the material which is indented and forms the direct quote is also in a lesser font, a smaller font than the standard ones. So if you're really observant, you'll pick up a lot, which will help you when it comes to writing your legal papers. Okay. I think, now I'm just looking at my notes. I've raced through a lot of things. I'll come back to written communication now. Professional presentation, yes, well referenced, logically written, short sentences, understandable content, plan your thoughts, use headings. A short document often takes longer to prepare than a longer one. Avoid some really terrible old-fashioned legal habits. Has anyone come across law firms that use things like, we refer to your letter of the 10th ultimo, or regarding our telephone conversation instant, which I think means yesterday? Well, we don't do that. It's very old-fashioned. Avoid overuse of capitalizing and underlining headings, but use a different font or bold or italics. You know that in the exam there will be a redrafting of gobbledygook question. And Catherine says a lot of people in the UK still do that. I know, it's pretty old-fashioned, sorry. Have a look at McDonald and Clark Dixon's clear and precise writing skills and go through the redrafting exercise. That's a note for me. So if you can bear with me, I will, in fact, I'll do that later. I might, in the interest of time, do that at a later time or put it on the website. All right, collaborating. A few tips. You've got to plan, you've got to cooperate, empathy. Really important when it comes to collaborating, aim to give more than you receive. If everyone goes into the collaboration with that objective, you should have some great success. Have a look at the group contract, which is on page 336 of the New Lawyer. And of course, we've just done that Humsey Hancock case, so there's some issues there in terms of collaboration. All right, I know I've moved through that last bit pretty quickly. Are there any questions? Okay. I'm just going to make a few comments now in relation to... Actually, I might leave it at that. It's been a long session already, so I might leave chapter 10 dealing with self-management skills to next week. Does anyone have a problem with that? All right. So what I need to do is provide you with some information in relation to redrafting. I'll put some notes on the website. I've also been thinking about reading skills and how you go about reading material. In law, you have so much material to get through, and I forget who I mentioned it to, this technique of highlighting. So I'll put some notes on Moodle and uCrew for that as well. All right, well, that might do us tonight for communication. Thank you, a big thank you once again to Catherine, and I'm sure that somebody else will want to volunteer pretty soon to do something else, possibly Peter, I'm not sure. Thanks, Peter. Yes, he's given me a nod. All right.
Thanks for that, John.
That's okay. Yeah, Catherine volunteered in the same way that you just did. All right. Any questions? Well, we might call it quits. I'll just stop recording now. Thank you.